and Ben Mendez.
Good morning, Your Honor.
We represent the defendant today, Leland Messi.
All right, thank you all. We're ready to begin with trial. For expediency, we're going to skip housekeeping matters, and instead I will read the following instructions to both parties, which I'm sure you've heard many times thus far. Attorneys, when you speak for the first time in trial, please state your name. Witnesses, you do not need to say your name. All witnesses are sworn in under EEO Rule 603 and constructively sequestered under Rule 615. During the trial, don't offer courtesy copies of documents to the court. We will all have the case file. Just refer to a witness statement by name or exhibit number. Please follow Imperion's procedures for handling exhibits and demonstratives at trial. You may move freely throughout your virtual will, and when it's your turn to examine, you can do that when it's your turn to examine witnesses or make a statement. A word of advice for handling exhibits in Zoom court: when you need a witness to identify an exhibit, simply ask the court permission to show the witness the exhibit like you would in person, and then screen share the exhibit. That exhibit will be constructively outside the view of the jury unless and until the court admits the exhibit into evidence. Any questions from anyone about this procedure?
Yes, Your Honor. Oh, sorry, go ahead.
Your Honor, specifically for screen sharing demonstratives, would you also like for us to ask for permission or state for the record?
I think it's fine if you just state for the record that you're doing that.
Yes, Your Honor.
Your
And
Honor,
to the defense.
one question in regards to Rule 615. We ask that our expert witness be allowed to be constructively present for today's trial within the means of Rule 615A3, as he's an essential part of our defense today.
Granted.
Yes, Your Honor. And with that, we're ready to go with openings.
Okay, great. Let me finish off on these instructions. If a student loses connectivity at any time, please have your coach contact the blue shirt lead in charge of the courtroom as soon as possible. And after each part of the trial, we'll take a moment to ensure our judges have been able to submit their scores and comments in the tabulation software. All right, with that, I believe we are ready to proceed. So, counsel for the prosecution, you may proceed with your opening statement.
Your Honor, we have actually a slight concern as to the pretrial. Your Honor, it's our understanding that the defense's party representative is only Leland Messi, and there's no exception to that rule.
Okay. Response?
Your Honor, our party representative is not going to be our expert witness. Of course, our party representative will be Leland Messi. We're asking that our expert witness be constructively present in court within the means not of 615B, but 615C, because he's an essential part of our defense in today's case and needs to hear testimony from the state's case in chief to assess the reliability of it in his testimony.
And I did review the rules in terms of who was permitted to sit in. Are you alleging that that is permitted under the Imperion rules?
Yes, Your Honor, if you look at Rule 615 and the Imperion rules.
Okay, response?
Your Honor, in that case, if they're not a party representative, we're perfectly all right with that.
Okay, fantastic. Is there anything else we need to take up before we get to openings?
Yes, Your Honor, we just like to designate Detective Davy Beckham as the state's party representative.
Okay, that'll be granted.
And with that, we're ready to go.
Okay, let's hear opening statement from the prosecution.
Yes, Your Honor. One more time for the record, my name is Anya Luo, on behalf of the state. To save her home, she shot the salesman. It's early morning, December 4th, and Leland Messi, the defendant, is on her way to Imperion State Capitol. She's dressed in dark clothes, pulls a mask over her head, and slings a duffel bag over her shoulder. Inside that duffel bag, there is a Glock 22 firearm hidden inside of it. And it's not for self-defense, because the defendant is angry. She's furious at one person, Ronnie Goodell, the CEO of a gambling company that wants to tear down her old hometown and replace it with a casino. No matter how much the public protested, nothing was gonna stop the deal. Except for one thing. If the CEO, the salesman, was killed. So that day, when the defendant reaches the parking lot in front of the Capitol, she takes aim at that CEO standing on the front steps and shoots and kills. To save her home, the defendant shot the salesman. That's why today, as the state of Empyrean, we have charged this defendant with murder. And so, we're going to show you how the defendant intentionally shot a gun that caused the salesman's death. We understand that by doing so, we have taken upon a burden to prove this charge beyond a reasonable doubt. It's not an easy burden, but it's one we're confident we can meet today, because we'll be walking you through every piece of evidence step by step with 3 simple facts: the shooting, the sale, and the suspect. First, the shooting. Members of the jury, you'll learn today from a senator about how she and the salesman have been striking a deal to legalize gambling in Empyrean and establish a brand new casino. The problem was, they'd have to be tearing down neighborhoods and displacing families from their homes. The defendant's childhood home was in one of these neighborhoods. It was bad enough that the state was legalizing gambling, but you'll hear today that she refused to lose her home over it too. And so to save her home, the defendant shot the salesman. Second, the sale. Members of the jury, an eyewitness who saw the whole shooting go down will tell you today about a description of the shooter. You'll learn that the shooter was wearing all dark clothing, carried a dark duffel bag. And when the defendant was arrested, well, she was found wearing those exact same dark clothes, carrying the exact same duffel bag. It was the same person. So finally, the suspect. A police investigator today will walk you through all of the evidence they found to make this defendant a suspect. Because when the defendant was first approached by the police, she didn't give her real name. Instead, you'll hear how she pulled a false ID out of her back pocket and hoped it'd be enough. But the police didn't stop digging. You'll learn today about all the evidence they found. A weapon with the same bullets from the murder. A journal where the defendant wrote about her hatred for the victim, and a confession that the defendant was at the Capitol at the time of the murder. To save her home, she shot the salesman. Members of the jury, we get it. People get angry, and nobody deserves to lose their home for a cause they don't believe in. But that doesn't justify murder. And so today, in this courthouse, the killer must be held accountable. So at the end of this trial, my co-counsel, Ms. Garcia, will ask you one last time to reach the only just verdict. And that verdict is guilty. Thank you.
Thank you, counsel. We will now hear from the defense for opening statement.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. Close enough isn't good enough. Now, the state just told you quite a shocking story. That a man storms down to Capitol Square, pulls out a gun on Bet Empire's CEO, Ronnie Goodell, and shoots him. But hidden in the details of that story, you're going to hear contradiction after contradiction. What if I were to tell you that there were people far more furious with Ronnie Goodell than Leland Messi? What if I were to tell you the state doesn't have reliable evidence connecting Leland Messi to the scene? And what if I were to tell you that Leland Messi doesn't even match the description of the shooter? Because here's what you'll learn the truth of this entire situation is. Ronnie Goodell, he was bulldozing homes to make way for his gambling headquarters and casino. These people, they were furious. He then announced in a press release, available to all of those furious people, exactly where he was going to be, December 4th, the morning of the shooting. And when that morning came, it was early, and it was cold. Everyone was dressed in dark, warm clothes, just like the shooter. The state's asking it to take a handful of similarities, say that's close enough, and call it a day. But close enough, that's not good enough, especially when the state is charging Leland Messi for such a serious crime. You see, when they accused Leland Messi of murder, they took on something called the burden of proof. That means it is solely their responsibility to prove to you that Leland Messi deliberately killed Ronnie Goodell. And they have to prove that by the highest standard in our justice system, beyond a reasonable doubt. What that means is if at the end of this trial, you're thinking, maybe something else could have happened. Maybe someone else could have done it. Or even if you just have important questions the state hasn't answered, well, then you'd have a reasonable doubt, and you couldn't find Leland Messi guilty. Now, I have 3 simple questions I want you to consider as we move throughout this trial. First, is Leland Messi the only one who could have done it? Second, does the state have reliable evidence connecting him to the scene? And third, does Leland Messi even match the description of the shooter? Now, I want to walk through each of these questions, starting with that first one. Is Leland Messi the only one who could have done it? Because today you'll hear from a journalist who will tell you that they interviewed people all over Pascal. People calling Ronnie Goodell a thief, saying that his deal was gentrification, saying that he was bulldozing the working class. Those people, they were furious. You'll hear about this press release announcing to all of those furious people where he would be the morning of the shooting at Capitol Square. Now, the state told you that Leland Messi, he shot the salesman to save his home, but him not having a unique motive or unique knowledge, that's not good enough. Any one of these people, they could have shot that salesman, or rather CEO, to save their homes. Which brings us to question 2. Does the state have reliable evidence connecting Leland Messi to the scene? Because today, they'll call an Uber driver to the stand. You'll hear that he saw Leland Messi 3 hours before the shooting. But that when he claims he saw Leland Messi, this was after an extra long shift of work, when he was pretty tired, at a distance before the sun had risen. And all at the same time, you'll hear that Messi's cellular records placed him on the other side of town. Which brings us to our third question. Does Leland Messi even match the description of the shooter? Because the shooter, he was seen wearing a black beanie, wearing a black hoodie, black pants, and carrying a black bag. But Leland Messi, he was seen wearing a green beanie, wearing a gray hoodie, gray pants, carrying a blue duffel bag. And members of the jury, close enough, that's not good enough. Now, I would like to acknowledge that Ronnie Goodell was murdered. And it's a tragedy. It's human to want answers fast, to want justice. I know you want answers, members of the jury. I want them too. But when we want justice to be swift, it's easy to miss the little details. And I trust, after hearing all the evidence, you'll be able to see those contradictions in the state story, those small things that don't add up. That's why my co-counsel, Ms. Bailey, is going to come before you once all that evidence is out, and she's gonna ask you to come to the only reasonable conclusion. To find Leland Messi not guilty. Because close enough is never good enough. Thank you.
Thank you, counsel. I'm going to give the judges a moment to finish up their ballots as it relates to the opening statement. All right, we're going to proceed with the prosecution case in chief. You may call your first witness.
This is Audrey Ma on behalf of the state, and we call Mr. Kai Mbappe to the stand.
Okay, thank you. You may proceed.
Yes, Your Honor.
Can y'all see me all right?
We can see you, Mr. Mbappe.
Oh, thank you very much. You know, nowadays with these, I think the youngsters call it the Zoom. It's a little bit confusing, so I appreciate y'all telling me if I got this right.
Well, thank you for wrestling with the technical difficulties to be here with us today. Could you please introduce yourself to the members of the jury?
Good morning, everybody. My name is Kai Mbappe.
What do you do for a living?
Well, I'm a retired postman. These days, I Uber part-time. Can't go playing bingo on an empty wallet.
How long have you lived in Pasquale?
I've lived here for a few years now. Been jumping around the East Coast before I settled down in this cozy little town.
Do you know why you're in court today?
Well, I watched this shooting unfold with my own two eyes. Reckon I'm here to tell y'all what I saw.
Speaking of what you saw, I want to direct your attention to the day of the murder. What were you doing on the morning of December 4th?
Well, I was working at 5:30 in the morning, 2 podcasts deep into a true crime series, when this true crime came knocking.
And at the time, where exactly were you driving?
Straight towards the Capitol. In fact, I was at Capitol Square that morning, going to get a cup of coffee.
Now let's talk about what you saw. Did anything catch your attention?
Well, I saw someone sprinting past in the dark, like a postman who has to deal with the same day delivery. All dark colors, a beanie, and a hoodie.
Were you close enough to see the person's face?
Sure was, ma'am.
And did you get a good enough look at their face?
Yes, ma'am. They passed under a street light.
Now, if I showed you the clothes that person was wearing, would you recognize them?
I would.
Your Honor, permission to share what's been pre-marked as Exhibit 7. Mr. Mbappe, were these the clothes that the person you saw was wearing?
Yes, ma'am. This is what I saw. That same beanie and same sweater.
Thank you, co-counsel. You can take that down. Now, it seems like you recognize the clothes of the shooter, but did you recognize the person wearing those clothes?
Yes, ma'am, I did. Later on, I found out via a news report that the person's name was Leland Messi.
Would you recognize that person if you saw them again today?
I would.
Your Honor, permission for Leland Messi to turn on their camera for witness identification purposes?
Absolutely.
Oh, Your Honor, we can have them constructively recognize Leland Messi. We don't actually have Leland Messi present today.
Now, Mr. Mbappe, is this the person you saw?
It is.
What did you hear next?
Well, all of a sudden, there's these loud pops, gunshots. Bang, bang, bang. It was like a bad drumline audition. And then there was silence. And then there was a man on the ground.
Who was it?
It was Ronnie Goodell. I saw him on the news. One of those salesmen with the big teeth and fake smile, dead as a doorknob.
Now, I want to talk about what you did after the shooting. Did you report what you saw?
No, ma'am, I did not.
And why not, sir?
At the time, I didn't know who the person was. I just saw someone in dark clothing with a duffel bag. I didn't realize what I'd seen until later on.
And today, how confident are you in identifying the person you saw that morning?
Very confident. The moment I saw the report on Messi's arrest, I knew it was the same person I had seen near Capitol Square. That's when everything connected. That guy I saw, that shooter, was Leland Messi.
Sir, did anything else happen on the day of the shooting?
Not that I could recall. After seeing it unfold right in front of me, I was pretty shaken. It wasn't like anything in the movies. It was raw and it was messy.
Thank you. Nothing further, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon, sir.
Good morning, sir. How are you today?
I know it's a Sunday, so I have a few yes or no questions for you before we can get you out of here. I'd like to first talk about that person you said you saw at 5:30 on the morning of the shooting. You work the night shift as an Uber driver?
I did, and normally I work these 9-hour shifts, but that day before I had to stretch it extra long.
So you started around 8 p.m. in the evening, though.
Yes, sir.
Your usual shift goes to 4 or 5 in the morning?
Yes, sir.
But as you said, you pushed it further.
Yes, sir. I had a little extra energy in me that day.
But you were pretty tired by 5:30.
A little bit, yes, sir.
A couple minutes later, you had to roll down your window to get the air to help keep yourself awake.
You got that right, sir.
And then at 5:30, when you're telling us you saw Leland Messi, he was over in a side street.
Yes, sir. Walking briskly towards the Capitol.
Well, you actually said he was sprinting like a mailman earlier. Isn't that right?
I did get that. I did say that. You got that right, sir.
And this was before the sun had risen.
That is true, sir.
Now, I want to talk about whether you could have been influenced to believe that this person was Leland Messi. Because the first time you saw that name was actually on the news.
Yes, sir. But the first time I saw that face was at 5:30 a.m. But that's a yes to your question.
So you saw it with the headline, "Suspected Shooter Arrested."
Yes, and then the name Leland Messi in these big bold letters.
So it was only after seeing that headline with those big bold letters that you identified Leland Messi as the shooter.
That's when I connected the dots. Yes, sir.
So the police, they never showed you a photo lineup to identify Leland Messi?
They did not.
So, sir, I just want to be clear here. You're telling us that after an extra long shift, when you were pretty tired at a distance before the sun had risen, and a news report were good enough for your identification?
Yes, sir.
All right. Well, I want to move on to what you may have seen more objectively. Because, sir, at 5:30, you thought you saw someone wearing all black,
That is correct.
carrying a black duffel bag,
Yes, sir.
and you don't recall seeing any blue or green or gray, do you?
Not that I can recall, sir.
Then at 5:45, you saw someone in all black again,
You have that right, sir.
carrying a black duffel bag.
Yes, sir.
And once again, you didn't see any blue or green or gray, did you?
I did not, sir.
But you thought this person had a mask on this time.
Yes, they had something slipped over their face.
You thought this mask was a beanie,
I did.
and you thought that beanie had eye holes.
I did.
Now let's move on to the shooting. That was at 6:45, right?
It was, and by then the sun had came out a little bit over those trees beyond her.
And with that sun up, you didn't see any eye holes on the shooter's beanie?
I'm sorry, can you repeat the question?
With the sun up there, you didn't see any eye holes on the shooter's beanie?
I did not, sir.
And the shooter, you saw him to be in all black,
Yes, the same as I saw Leland Messi at 5 in the morning.
carrying a black duffel bag.
Yes, sir.
And once again, you don't recall seeing any blue or green or gray under the sunlight.
No, not that I can recall.
Thank you. Thank you for your time. No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
Go ahead.
Mr. Mbappe, on cross-examination, you just got asked a lot about how you saw Messi and then how you identified them later. And I want to ask you a little bit about how you can identify somebody that you might not have seen before. Now, if I have my co-counsel turn on their camera, you can't see her name, right?
I cannot.
But if you were to see her again, would you be able to describe her features to the police?
I would, ma'am.
Could you describe those features right now for me?
Sure thing. It's a female. She's got this orange overcoat and this black hair.
Thank you. Nothing further, Your Honor.
Thank you. Anything further from the defense?
Yes, Your Honor, we have a recross.
Go ahead.
Sir, when Miss Garcia was just up there, there was good lighting.
Yes, sir.
Your computer with her face on it, that was right in front of you.
Yes, sir.
You saw her for more than a couple seconds.
Yes, sir. Just like I did with Leland Messi.
She wasn't sprinting around.
Not that I could see, unless it maybe my screen was frozen again these Zoom calls. No, sir.
Thank you. No further questions, Your Honor.
Yeah, I'm not sure how many times I'm allowed to let that go back and forth. Or, prosecution, are you done with this witness?
Yes, may Mr. Mbappe get back to Uber driving or maybe bingo?
You may. You may step down, sir. Give us a moment to finish our ballots, and then you may call your next witness.
Have a great day now, everybody.
Thank you,
Thank
sir.
you, Mr. Mbappe.
All right, the prosecution may call its next witness.
Yes, Your Honor. We now call Senator Mackenzie Ham to the stand.
Okay.
Good morning. Can you please introduce yourself to the court?
Good morning. My name's Mackenzie Ham.
Ma'am, what do you do for a living?
Well, I'm proud to be a senator for the Empyrean State Legislature. And I've actually been in the position for nearly 22 years, representing the people of DeMent County for all of these years.
So, Senator, how'd you get into this line of work?
Well, I've always wanted to be a politician after seeing Obama's speeches. So in 7th grade, I ran for student council. You know, I told everyone, vote Ham and you'll pass all your exams. Guess it worked because I got elected. Although that might have been because I brought everyone in the grade cupcakes.
So, as a senator, what kinds of things do you do?
That's an excellent question. So right now, we're focused on encouraging economic prosperity in all of its forms. And we do that from supporting small businesses to million-dollar corporations. I mean, you know what I always say. Vote Ham, and policy changes will be as sweet as Thanksgiving dinner. These policy changes actually included the recent gambling deal we made with Ronnie Goodell.
Who's Ronnie Goodell?
He's the CEO of Bet Empire. That's a gambling company.
And so, what kind of deal were you trying to make with the salesman?
That's another great question. And to understand that, let's take a few steps back. So recently, I helped enact Senate Bill 1968, which, in simple terms, it legalized online betting in our state, and it also allowed for new waves of economic prosperity. And I was confident that we could do some good.
Well, ma'am, from what you saw, was this bill popular?
It's in the interests of Empyrean's economy, of course, although I do understand that there have been some small protests.
Have these protests over the bill ever gotten violent?
No, not at first. Just some crowds in front of the Capitol with signs. Nothing, well, further till the shooting.
Ma'am, this may be difficult to talk about, but let's go through the events leading up to that shooting. Where were you that day?
Well, I was at the Capitol. It would have been around 6:20 in the morning. I mean, we were going to announce the relocation of Mr. Goodall's company into Empyrean.
Were you alone?
No, of course not. My security detail was right behind me, and I was with Mr. Goodall.
So you were with the salesman. Well, what happened after?
Well, we started walking together toward the Capitol, and that's when the shots rang out.
Maybe tough, ma'am, but we're going to try to bring this moment to the members of the jury. So the shots rang out. You're on the Capitol steps. What happens?
I think my security tackled me, and I might have hit my head.
Do you remember the number of shots?
It all happened so fast. I remember hearing 2, maybe 3 shots.
Were you hit, ma'am?
No, but I just looked to my side. I saw a body on the floor. And that was Ronnie. And there was so much blood.
Ma'am, would you like a minute?
No. Let's go.
We're almost done, ma'am. So who'd you see at the Capitol that day?
Not that many people. Just me, my security, Ronnie, and that shooter that ran away.
Ma'am, if I were to show you a map right now, could you tell the court where everyone was standing that day?
I could.
Your Honor, permission to screen share Exhibit 1D, which has already been pre-admitted into evidence pursuant to Stipulation 11. Ma'am, what does this photo show?
That's a picture of the Capitol. That blue X mark on the left. That's where Mr. Goodall and I were standing. And the one on the right, the red one, that's where the shooter was.
Were you able to get a good look at the shooter?
Yes.
Can you tell the jury, ma'am? What was the person who shot Ronnie Goodell wearing?
They were wearing a dark colored hood sweatshirt, and a beanie, and they were carrying a bag. And they just ran away.
Thank you for your time today, Senator. Nothing further, Your Honor.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Good afternoon, Senator.
Good afternoon, sir.
I want to thank you for taking time out of your busy schedule to be here with us today.
Thank you, sir.
Now, Senator, wouldn't you agree with me that some of the constituents in your district, they don't really get the bed empire deal?
Yeah, they don't. There were a few small protests.
I want to get to what you described as small protests in just a minute, but wouldn't you say that there's a pretty vocal portion of the community that is outspoken against your deal?
Yes. There were people around the Capitol building protesting.
Right. Senator, at one of your recent town halls, there were 50 protesters, isn't that right?
That's right.
Those protesters, they got pretty rowdy, didn't they?
They did, yeah.
They were chanting what you considered to be threats at you.
They were calling me all these horrible names.
Senator, you told us that you believe these to be small protests, but isn't it true that there have been about a dozen other protests at the Capitol building?
That's right. About a dozen little skirmishes all around Capitol building.
Senator, you keep saying that these were little skirmishes, but the protests at Capitol building, they were much larger than the protests at your recent town hall, weren't they?
That's right. Quite a few people were upset with our bill.
Much larger than 50 protesters.
That's right, sir.
Senator, I understand that it is a difficult topic, but we've got to talk about what you saw on December 4th. Now, on December 4th, when that shooting occurred, the sun had risen, hadn't it?
Yes, sir. It had.
And you're absolutely certain that you're absolutely certain about one thing, the color of the shooter's clothes, aren't you?
That's right, sir. I'm 100% certain what I saw.
You are absolutely certain that those clothes were black.
That's right, sir.
Not gray or blue or green, but black.
Black, sir. With the shooting and everything, you don't forget that kind of thing.
I want to talk about whether or not you could have forgotten that kind of thing, Senator. Because
Sir, I didn't.
let's get to that, Senator. Wouldn't you agree with me that your memory of December 4th has been somewhat altered by the experiences you went through?
No, sir. I remember what I saw. I won't ever forget it.
Senator, isn't it true, though, when those shots rang out, your security detail tackled you?
Yes, sir. Emerson was just trying to protect me.
He tackled you onto the steps of the Capitol building.
She actually, but yes.
And when your security detail tackled you onto those steps, you hit your head pretty hard on them, didn't you?
I did, yes. The doctor told me I had a minor concussion.
On direct examination, you actually told us you couldn't really remember. You said you think you might have hit your head pretty hard, but it is true that your doctor told you you may have a concussion from that.
My doctor told me I did have a minor concussion. Sir, I assure you, I remember what I saw. You don't forget that kind of thing.
Isn't it true you can't remember if you heard 2 gunshots or 3 gunshots?
2 or 3, sir.
You can't remember what time you were supposed to arrive at the Capitol building that morning, can you?
Sir, I was supposed to get there around 6. I was just running late.
But Senator, on December 4th, when the police interviewed you, you couldn't remember exactly what time you were supposed to show up at the Capitol building?
No, sir. I was in shock at what I saw. I mean, Ronnie just dropped dead right next to me.
Now, Senator, after Mr. Goodell was shot, you looked over at him, didn't you?
I did, and there was blood just everywhere.
Senator, I understand that it's difficult, but it is important that we get specific here. You observed 3 gunshot wounds, didn't you?
I did, sir.
2 in Mr. Goodell's back
That's right.
and 1 in Mr. Goodell's leg.
That's right, sir.
As you've been telling us all day today, you're certain about that, aren't you?
I am, sir.
You're just as certain about that as you are the rest of the facts that you've testified to today.
Sir, I know what I saw.
Senator, you went to the hospital with Mr. Goodell, didn't you?
I did, but it was too late.
I understand, Senator. When you went to the hospital, they conducted an autopsy.
They did.
You were present for that? You actually helped identify Mr. Goodell?
That's right, sir.
You'd recognize that autopsy if I showed it to you, wouldn't you?
I would.
Your Honor, permission to screen share pre-admitted Exhibit 5, that autopsy.
You may.
Senator, this is the autopsy that was conducted, isn't it?
That's right, sir.
I want to read off a couple portions from this autopsy, starting at the findings section. Under the external examinations portion, I'm going to read aloud. Let me know if I read correct. Externally visible trauma consisted of 3 circular wounds, 1 in the lower left abdomen and 2 matching circular wounds in the lower left back. Did I read that correctly?
That's right, sir.
And then under the conclusions portion, I'm going to read again. Probable cause of death is massive trauma caused by multiple gunshot wounds to the back, stomach, and abdomen. Did I read that portion correctly?
That's right, sir.
Nowhere in this report is there ever mentioned a wound to the leg. Isn't that right?
No, sir, I don't believe so.
Thank you, Your Honor. I have no further questions for the witness.
Thank you, sir. Redirect.
Very briefly, Your Honor.
Go ahead.
Senator Ham, are you an expert in gunshot wounds?
No, by no means, ma'am. I'm a senator.
Are you an expert in the body and all the different parts of it?
No, ma'am.
So what were you telling the court about what you saw?
Ma'am, I heard 2, maybe 3 gunshots, and then Ronnie was just on the floor bleeding out.
Thank you, Senator. Nothing further, Your Honor.
You recross?
No, Your Honor.
Okay, this witness may step down. Thank you. We'll take a moment for the judges to finish their ballot on this portion. All right, prosecution, you may call your next witness.
Yes, Your Honor. Stating for the record, this is Christiana Garcia for the state. At this time, we call Davy Beckham to the stand.
Thank you.
Hello.
Good morning, ma'am.
Please introduce yourself.
Hello, my name is Davy Beckham.
Where are you from?
I hail from Bradford, England. I moved to the States in my 20s and have been here ever since. I told my mum it would just be a gap year, but 25 years, 1 child, and a mortgage later, here we are.
What do you do for work?
I'm a detective at the Imperial State Police Department, and a full-time mum, which frankly means I've had years of training in spotting lies and negotiating with unreasonable suspects under 4 feet tall.
What's your educational background?
Well, I spent a good number of years with my head in the books. I got a bachelor's in criminology and a master's in forensic science.
Can you tell us why you're in court today?
Sure, I was the lead investigator in the awful shooting of Mr. Ronnie Goodell.
How did you investigate the shooting?
I used what I call the SOS method. And no, it's not just for sailors stranded at sea. It's also for detectives drowning in paperwork, because it's how we figure out the steps of an investigation. I actually created a visual aid to break down this process.
Stating for the record, we'll now be screen sharing that visual aid created by Detective Beckham. What does SOS stand for in this context?
The first S stands for shooting, next comes the O for observations, and finally the last S for suspects.
You heard the defense say close enough isn't good enough. Did you settle for close enough in your investigation?
No, ma'am, of course not. We did a thorough investigation following the SOS method.
Let's talk about that first S in the SOS method. When was the shooting?
December 4th, the shooting took place on the steps of Capitol Square.
What happened?
Mr. Goodell, he was the CEO and was shot multiple times by an unknown shooter. Sadly, he did not survive his injuries.
After the shooting, what did you do?
My next step was speaking with every witness who was in the area of the shooting, asking questions like if they saw the shooter's face or where they heard the shots come from.
What did you learn?
The witnesses said they saw a single person wearing dark clothing, carrying a...
The hearsay may I be heard? May I be heard, Your Honor?
Can you hear me?
Oh, I couldn't, but now
Yes.
Okay, go ahead.
This witness is delving into what is hearsay testimony now. They're offering these statements from what they heard at witnesses at the scene of the crime, and they're using it to prove the truth of the matter asserted, that these things are actually true about the shooter.
Pause.
Your Honor, may I be heard?
Please.
Your Honor, we're not using these statements describing the shooter's clothing for the truth of the matter asserted. Because the truth is, we've already called 2 witnesses on stand who said their testimony describing the shooter's clothing, and that was being used for the truth of the matter asserted. We already have these quotes on the record. Hence, as of right now on Detective Beckham, we're not using these quotes for the truth of the matter asserted, so it's not hearsay. Rather, we're using it for the subsequent action.
May I respond?
Briefly, yes.
Your Honor, we believe they absolutely are using it for the truth of the matter asserted. We actually have it on a good faith basis that Detective Beckham interviewed over 30 witnesses. We believe opposing counsel saying that all of those witnesses saw this description of the shooter that matched the defendant. It's what they said on their opening statement, that they're going to prove that the defendant matched the description of the shooter, that the description of the shooter was wearing dark clothing, carrying a duffel bag, and had a gun, I believe. That's the truth of the matter asserted. It's not the detective's subsequent action.
Your Honor, may I be heard?
No, that's fine. I'm going to overrule the objection and allow it for the effect on the listener, and we'll instruct the jury that they're not to consider this portion of the testimony for the truth of what's being stated. You may proceed.
Yes, Your Honor. Continue, ma'am, about the description of the shooter's clothing.
Right, so the witnesses said they saw a single person wearing dark clothing, carrying a duffel bag, and also holding a gun. So afterwards, the law enforcement units were on a lookout for a suspect matching that description.
Did you find anyone who matched that description?
Yes, ma'am. A few days after the shooting, I was alerted to a suspect at a boat dock who matched the description of the shooter, and so I went down to investigate.
Let's talk about the O in your SOS method. What does it stand for?
Observations. So I approached the suspect, later identified as Leland Messi.
Hold on, ma'am. The defense says the defendant was misidentified. How did you identify her?
Well, I used my magnifying glasses, these peepers, and note that she had a dark-colored hoodie and a beanie on. That's what matched the shooter's description.
Let the record reflect we've added a check mark next to dark clothes.
And also reflect.
What else did you find?
There was a duffel bag.
What's on screen?
Let's see. This is the duffel bag that I found the suspect with.
We move to enter Exhibit 6 into evidence.
Any objection?
No objections, Your Honor.
6 is admitted.
Let the record reflect we've added a check mark next to duffel bag.
So noted.
The defense says we don't have solid evidence against the defendant. Did you find any solid evidence?
Well, yes, ma'am. I searched the defendant's bag and I found a Glock 22 handgun and a journal as well.
Is this the gun you found?
Yes, ma'am. This is the Glock 22 I found in the bag.
Fair and accurate?
Yes, ma'am. It appears so.
We move to enter Exhibit 8 into evidence.
No objections.
It's admitted.
Let the record reflect we've now added a check mark next to gun.
Also
To your
reflect.
knowledge, yes, Your Honor. Detective, to your knowledge, what gun shot the salesman?
Well, from a close look at the test we ran at the police station, it was a Glock 22 as well.
What did you do next?
Well, I spoke with the suspect.
Did you observe the defendant being honest during your talk?
No, ma'am. He lied actually and gave me a fake identification card.
What did you do after she gave you a fake ID?
Well, naturally, I made the arrest and we headed down to the station where we sat down and I asked them a few questions.
Let's talk about the last letter in your SOS method. What was that final S for?
That was for suspect.
The defense says the defendant wasn't there at the scene of the crime. Did you find any evidence of that being true?
No, ma'am. Actually, the suspect, Mr. Messi, said that he was downtown the day that the salesman was shot.
Did you find any evidence that she had a motive to shoot the salesman?
Well, the suspect did say that his home was being sold because Mr. Goodell planned to build a casino there and displace families.
Let the record reflect we're now adding a check mark next to location and home. What are we looking at?
This is the journal entries that I found on Miss Messi.
Take a closer look. Is it fair and accurate?
Yes, ma'am. This is the defendant's writing, and I know it's her writing because during the interview she said it was hers.
This time we enter Exhibit 9C.
Any objection?
None.
9C is admitted.
Can you read the note from December 3rd?
Yes. So it says, new plan calls for demolishing the Leesa neighborhood next summer to build their stupid little casino. A bunch of traitors. 6 months to stop it. Let's go.
Ma'am, today we heard the defense say a lot of people had a motive to shoot the salesman. In your investigation, did you find anyone else who wrote this in their journal?
No, ma'am. It was just the defendant who wrote this in her journal.
Well, did it take 6 months to stop that sale from happening?
No, ma'am. It was actually just one day after the defendant wrote this, the salesman was shot, and that halted the sale. and saved the defendant's home.
Understood. Thank you, ma'am. At this time, Your Honor, no further questions.
Counsel, cross-examination.
Yes, Your Honor. Good afternoon, Detective Beckham.
Good afternoon, ma'am.
Firstly, just want to talk about something you said on direct examination. Miss Garcia asked you if anyone else wrote that about Ronnie Goodell in their journal, didn't she?
Right. She
It's
did.
true you didn't read anyone else's personal journal in your investigation, though, right?
That's right. Miss Messi was the only one who had the journal.
All right. Then I want to move on to talk about whether or not it's reasonable that Miss Messi wouldn't have left DNA and fingerprints at the scene of the crime. Now, you'd agree with me that you interviewed about 30 witnesses in preparation for your investigation, right?
That's right. 30 eyewitnesses.
None of these eyewitnesses described the shooter as wearing any gloves, did they?
No, there was no mention of gloves.
You searched Mr. Messi's duffel bag, didn't you?
That's right.
You didn't find any gloves in there.
No, there was just the gun, among other things.
Searched Mr. Messi's person.
That's right. He had no gloves on.
All right, then let's move on to talk about whether that's reasonable with your account of the shooting. Now, you believe that the shooter lay in wait for about half an hour before the shooting actually happened.
That's right, at about 6:15 a.m.
Specifically, you believe Mr. Messi at 6:15 crouched between two cars.
That's right. Some of the eyewitnesses did say they saw the shooter crouched between two cars.
Ma'am, you'd agree that if someone's crouched between two cars for half an hour, they might put a hand out to try and stabilize themselves.
I wouldn't know. I also wouldn't know if she had gloves on or not.
Well, you didn't find any evidence that she had gloves on, did you?
That's right.
All right, you tested the entire crime scene for DNA, didn't you?
No, just the shell casings, ma'am.
Ma'am, you didn't test the crime scene for DNA evidence?
That's right. I tested the shell casings from the shooter as well as the gun from Miss Messi.
You didn't test the crime scene for DNA evidence or fingerprint evidence?
Not the crime scene itself. We tested the shell casings, and I sent them to the crime lab for testing.
Ma'am, did you find any of Mr. Messi's DNA on those shell casings?
Well, I didn't do the testing, but I'm sure the forensic investigators did.
I'm sorry, you're telling us the forensic investigators found Mr. Messi's DNA on the shell casings at the scene of the crime?
No, ma'am, I never said that.
I'm sorry, what did you just tell us?
The forensic investigators did the testing. I simply was the one who sent the shell casings to the crime lab.
All right. But you didn't test the scene of the crime for any forensic evidence other than those shell casings.
That's right.
All right, then I want to talk about whether Leland Messi actually matched the description of the shooter. Now, you'd be familiar with the clothing recovered from Mr. Messi if I showed it to you today.
Yes, ma'am, I would.
And you'd be familiar with that duffel bag as well, the one shown to you on direct?
Of course, ma'am.
Your Honor, permission to display already admitted exhibits 6 and 7 on the screen. And now, you'd agree with me that these look like what Mr. Messi was wearing and carrying when you arrested him.
Yes, ma'am, that looks right.
Now, you had quite a few eyewitnesses tell you that the shooter was carrying a black duffel bag.
Right. The witnesses all said that they were carrying a dark duffel bag. Some of them said there was a black duffel bag.
You'd agree with me that that duffel bag is blue.
The one shown on screen, yes, it's a dark navy blue.
Now, your investigation also concluded that there was a suppressor on the gun that the shooter used.
Right, it was very likely that there was a suppressor or a silencer used on the Glock.
You searched Mr. Messi's bag for a suppressor.
That's right, and we found none.
You didn't find any evidence of Mr. Messi owning a suppressor at all.
That's right, we did not find a suppressor or a silencer.
Now, it's also true that none of the witnesses you interviewed could positively identify the shooter's face in a photo lineup, right?
That's right. The witnesses all said that the shooter was masked.
So you didn't have any witnesses who could see the shooter's face.
That would be reasonable to say, yes, ma'am.
You didn't have any video surveillance of the shooting?
That's right.
So you don't have any photographic or video or forensic evidence placing Mr. Messi at that scene, right?
Yes, ma'am. It's very likely that the suspect had already walked the area and known the security cameras. But that's a yes to your question.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. Detective Beckham, Miss Bailey just got up here and asked you about your investigation. I want to take a closer look about the test you ran. You told us you didn't run DNA test. What test did you run?
Well, we did run a DNA test. It was on the gun that Miss Messi had.
Did you find her fingerprints?
On her gun, yes.
And the gun that she owned, what type of gun was that?
That was the Glock 22 handgun.
Glock 22. Is that the gun that you found in your investigation shot the salesman?
That's right. Again, Miss Messi owned a Glock 22, which was also the type of gun that shot the salesman.
Thank you, Detective. Your Honor, I have no further questions.
Do you any recross?
Briefly, Your Honor.
Please.
Detective Beckham, you just told us that you found Ms. Messi's DNA and fingerprints on her gun, right?
That's right, on the gun that she owned that was in her duffel bag.
Right, you'd agree with me, she owns that gun.
Oh, well, of course, ma'am.
It was in her possession.
That's right, again, it was in her duffel bag.
Now, you also told us that it was a Glock 22, but you'd also agree that that's a pretty common make and model.
That's right, it is widely used, especially by law enforcement.
Thank you. No further questions, Your Honor.
Counsel, anything further?
No, Your Honor, may Detective Beckham step down.
Yes.
We rest our case in chief.
Okay, thank you. Per Imperion Rules of Procedure, we will take a 5-minute recess unless either side has an objection.
No objections here.
No objections from us either, Your Honor.
Okay, fantastic. If the timekeepers would please start a timer for 5 minutes, we'll reconvene in 5. Thank you. All right, I'm going to give a moment to make sure that we have all of our judges back. Doesn't appear we have everybody yet. Mr. Smith, are you on? I'm not seeing you. Okay, there he is. All right, I think we are good to go. Are both sides back and ready to proceed?
The state is back and ready to proceed.
Counsel?
The defense is back and ready to proceed.
Right, with that, defense, you may call your first witnesses.
The defense calls Harper Solo. One moment, Your Honor. Oh, there we go. Good afternoon, Miss Solo.
Good afternoon.
Can you please state your name for the record and spell your last?
My name is Harper Solo, Solo spelled Solo.
What do you do for a living, Miss Solo?
I'm a real estate journalist. I focus more on land deals, zoning laws, backroom negotiations, things of that nature. I have dreamed about being an investigative reporter on more serious issues like taking down shady politicians and exposing corruption. And this case was a little bit of both, so I was really excited to be reporting on it.
Have you had success as a real estate journalist?
It's a hard business, but I get it done, and I do it good. I'm just glad I can be here to help put an end to this debacle and help crack the case.
So do you know what you're here to testify about exactly?
Yes, I was reporting on the issue of the land sale and how the community felt about it.
Oh, well, let's talk about how they felt about it. Did you have any interviews in that community?
I did. I had a handful of interviews leading up to the announcement of the land sale.
Your Honor, permission to put up a demonstrative to assist with this testimony?
You may.
Will be just one moment. There we go. So, Miss Solo, could you tell us what these people said about that deal?
You know, most people called it steamrolling of the working class. Others called it gentrification. The word
Objection, Your Honor?
Yes.
On the grounds of hearsay, the witness is testifying to out-of-court statements made by the residents of Imperion, and they're being offered for the truth of the matter asserted. And under 801, that's hearsay.
Awesome.
Yes, Your Honor. Under 801C, we're not using these statements for the truth of the matter asserted. That truth would be that Ronnie Goodell is actually a thief, that he's steamrolling the working class, but we would have no reason to care about any of that. What we care about is that these people believed he was steamrolling the working class and believed that he was a thief.
And what's the relevance of that?
Your Honor, the relevance of that is that we believe this would give these people a motive for the murder of Ronnie Goodell, the same motive the state's been talking about that Leland Messi has in their opening statement and this whole trial.
Anything else from the prosecution?
Your Honor, opposing counsel just admitted why this is inadmissible under hearsay, because they are using it for the truth of the matter asserted. They just mentioned that it's showing that other people might have had a motive, and that's being used for the truth of the matter asserted.
Ruled.
Could you repeat that, Your Honor?
Ruled.
Yes, Your Honor. So, Ms. Solo, could you tell us what those people said?
most people called it gentrification. Others called it steamrolling of the working class. the word theft was thrown around quite a bit. The bottom line was that not a lot of people were happy about the deal, and those who were going to be making a buck off of it.
Now, were you hearing about this deal anywhere else apart from these interviews?
Yeah, so I did hear Bobby Parsons denounce the deal on his show, EM Power Hour, as well as I did read a press release on the deal.
Your Honor, let the record reflect that this press release has been pre-admitted as Exhibit 15. Now I want to talk about that press release and what it says about Ronnie Goodell and his company. But first, could you tell us what it's about generally?
Yeah, so basically it just details Bet Empire's plans of setting up a headquarters and a casino in Empyrean, and yeah.
Did it say anything about past gambling laws?
Yeah, so in the past, historically, Empyrean has prohibited gambling of any kind in the state. However, in 2023, they did pass a law legalizing sports betting in the state. After this, a few sports betting companies have been circling the area, thinking about setting up a headquarters or something like that in the city.
What about Ronnie Goodell's company?
Ronnie Goodell's company, Bet Empire, had plans of setting up a corporate headquarters and a casino in Empyrean, and these plans had been approved by Empyrean state legislature.
And would there be any consequences for Bet Empire's plan?
Yeah, so several families were to be displaced or relocated. Neighborhoods were to be destroyed, including parts of Liza and Empyrean.
And did this press release say anything about public appearances for Ronnie Goodell?
Yeah, there was going to be a press conference announcing the resolution of the deal on December 4th around 9 a.m. in the morning. That was the day of the shooting.
So was that public information?
Yes, it was.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. May I proceed?
Please.
Good morning, Miss Solo. I want to pick up where you left off about the deal, and maybe together, like you said, we can crack this case, all right?
Yes, hopefully.
Now, you talked a lot on direct examination about how some people were unhappy about the sale, and I wanted to talk about that.
Mm-hmm.
Your Honor, stating for the record will now be screen sharing the demonstrative that opposing counsel just used on direct examination. Does gentrification have anything to do with shooting a salesman?
I mean, that's how the people thought about the plans of setting up a corporate headquarters in Empyrean.
Ma'am, leading you back to my question, I was just asking, does gentrification have anything to do with shooting a salesman?
No, because these interviews I conducted were before the shooting of Ronnie Goodell.
So that's a no to my question?
No. Yeah.
And does steamrolling the working class have anything to do with shooting a salesman?
No.
And does theft have anything to do with shooting a salesman?
No.
And you heard all these quotes, but did you ever hear anyone saying they wanted to kill Ronnie Goodell?
No.
Thank you, co-counsel. You can take that down. You were also there on the day of the murder, right?
I was, yes.
Now let's see if you were close enough to get a good enough view of the shooter. You were near Capitol Square that morning, correct?
I was. I had a bit of a crazy night. I was just going back to my hotel.
And this was around the time of the shooting?
Mm-hmm.
You saw someone dressed in black.
Yeah, it took a second for my eyes to focus because I was pretty hungover, but they were wearing black.
And if I showed you those clothes, would you recognize them?
If they were black, then yes.
Your Honor, permission to screen share what's been pre-marked for identification as Exhibit 7. Now, were these the clothes you saw the shooter wearing?
I mean, again, it took a second for my eyes to focus, but they're pretty generic. Yeah, they resemble the clothes that the shooter was wearing.
The prosecution at this time moves to admit Exhibit 7 into evidence.
Objection.
Your Honor, we believe Exhibit 7 has already been admitted into evidence.
It's certainly been referenced multiple times. I don't have it unless it was pre-admitted. It was not offered by the prosecution.
In that case, we have no objection, Your Honor.
All right, seven's admitted.
Now, this person that was wearing these black clothes that you just identified as similar, they were walking towards the Capitol, not away from it, right?
Yeah.
Thank you, co-counsel. We can take that down now. And all of this you witnessed before shots were fired.
Mhm. Yeah.
Your Honor, permission to screen share what's been pre-marked for identification as Exhibit 6.
Actually, 6 has been admitted, so you can just put it up.
Yes, Your Honor. And Miss Solo, this was the duffel bag you saw on the day of the murder, right?
Yeah, it was just open on the street on the sidewalk as I walked past it.
Thank you, co-counsel. You can take that down. Now let's focus on when you gave your statement to the police. You spoke to the police that day, right?
No, I didn't.
You spoke to the police after the shooting.
Not really, not directly, no.
And you remember what you saw?
Yeah.
You remember seeing someone dressed in all black.
Yeah, after my eyes took a second to focus, then yes, I did.
And you remembered seeing that navy duffel bag.
Mm-hmm. Yeah.
Thank you, Miss Solo. No further questions, Your Honor.
Correct?
Yes, Your Honor.
Go ahead.
Solo, I want to briefly discuss the events of the day of the shooting, if you got a good enough look at what you saw. But first, could you tell us what you were doing the night before the shooting?
Yeah, so the night before, I went into the city to conduct some interviews, get some background on the shooting, or no, on the deal, sorry. And then, you know, I had an old fashioned to be classy. Old fashioned led to a whiskey sour. The whiskey sour led to a Manhattan. I had a few rum and cokes. That's my favorite drink. I would have had one this morning, but I'm at work, so I made it virgin. And then, you know, I got wasted and found myself walking on the streets in the morning, going back to my hotel, hungover.
Did you sleep at all between when you started drinking and when the shooting happened?
No, I didn't get a wink of sleep.
So, Miss Solo, do you think the sleep deprivation and the drinking affected what you saw?
100%. Like I mentioned on cross, it took a second for my eyes to focus and someone was calling the police, but it was kind of hard for me to hear them. Again, piercing headache.
So are you certain of what you saw that day, ma'am?
No, I can't be for sure certain.
Thank you. No further questions, Your Honor.
Thank you. Anything further from the prosecution?
Nothing further from the prosecution, Your Honor.
Okay, this witness may step down.
Thank you.
Give us a moment to do our ballots, please. Defense, you may call your next witness.
Yes, Your Honor. The defense calls Charlie Ronaldo to the stand.
You may proceed.
Yes, Your Honor. Good afternoon.
Good afternoon.
Please state your full name for the record, spelling the last.
Sure. Charlie Ronaldo, Reynaldo.
Mr. Ronaldo, what do you do for a living?
I'm a DJ. My stage name is Ronald Twizzy, Twisty T, the Teaminator. You can find me on Instagram at TwistyT13. The first 12 were taken, unfortunately, there.
Sir, do you know why you're here to testify in court today?
Well, yeah, I'm here to clear my friend's name, Leland Messi. I just don't think that they did this, and I couldn't imagine them doing something like this.
Sir, we'll get to that in just a moment, but first I want to start by talking about your relationship with Mr. Messi. Do you remember when it was that you first met him?
Yeah, I think it was 4th or 5th grade. And, him and I used to shine shoes downtown, just to make a few extra bucks. But, he was always real good at it. You could see the hair on a bald man's head after. And there were a lot of bald men down there. We did like downtown and stuff. So lots of rich people.
I'm sure. Have you stayed in contact with Mr. Messi, stayed friends since the time that you met him in 4th grade?
Well, yeah, we went to high school together. We went to college together. We moved back from college together. So, him and I have been friends a long time.
Mr. Ronaldo, during the time that you've known Mr. Messi, have you ever seen him become violent?
Oh, no, never. He's usually the one breaking up the fights, not starting them. I mean, the guy's vegan, for heaven's sake. I go over to his house.
Objection. As to character evidence, specifically the trait as peacefulness, may I be heard?
Please go ahead.
Your Honor, under Rule 404A1, this is improper character evidence. The defense is currently introducing the defendant's character trait of peacefulness, and they're using it for propensity purposes, saying the defendant's a peaceful person. He's a vegan. Of course he didn't shoot the salesman.
Pause.
Yes, Your Honor. This is peacefulness is actually a pertinent trait of the accused in this case. It is admissible under the character evidence rules because Mr. Messi is the defendant in this case, and the trait of peacefulness is pertinent to the allegations against him.
Your Honor, may I be heard?
Sure.
Your Honor, under Rule 404A2A, they are allowed to introduce pertinent traits of the defendant, like a peacefulness. However, they are not allowed to use it for propensity purposes. Your Honor, may I proffer?
Sure.
We believe they are currently using it for propensity purposes, saying the defendant is a peaceful person, hence he's more likely not to have shot the salesman to save his home.
So what do you view as the difference between propensity evidence and character evidence as it relates to peacefulness?
Yes, Your Honor. We believe it's a fine line. We believe it's okay to say he's a peaceful person. However, as Mr. Ronaldo just said, he was always the one breaking up fights. That implies that he always is breaking up fights, and that he is going to continue breaking up fights, and that he is going to continue being a peaceful person, which is propensity.
What?
Yes, Your Honor, this is absolutely appropriate character evidence. We're not using it for propensity in this case. In State v. Gorin, it's outlined that character traits like peacefulness are admissible character traits for the accused in a murder case.
Objections
Your Honor,
overruled.
may
You
I
can
be
certainly
heard?
no objections overruled. You can certainly cross-examine on it.
Certainly, Your Honor, I plan on.
Sorry, Mr. Ronaldo, would you like me to re-ask the question, or do you remember where you were?
I mean, I think I remember. I was just saying, he's a vegan. He drives me nuts sometimes with his tofu stuff. I mean, to save the animals and whatnot.
During the time that you've known Mr. Messi, have you ever heard him advocate for any violent means of protest?
No, never.
Mr. Ronaldo, have you and Mr. Messi ever discussed the Bet Empire deal together?
Yeah, he showed me, this press release for the deal, and when he first showed it to me, he got all red. He was a little bit upset, but I think everyone from Lisa was pretty upset when they first heard about it.
Or what makes you think that other people in Lisa were upset by that deal?
Well, I mean, have you seen the protests around town, Mr. Austin? They get pretty.
Objection. As to speculation, to the other people being upset about the sale.
Response?
Well, yes, Your Honor. This is based on the witness's rationally based perception. The witness has stated that they've seen many protests against this deal around town. It's certainly within their rational perception to say that the protesters appear to be upset about the deal.
Your Honor, may I be heard? Your Honor, we're lacking foundation about the specifics of the protesters and the specifics about why he believed they were angry. See, Your Honor, there sometimes are peaceful protests, simply advocating for different changes in our government. There's a difference between a peaceful protest and one of angry mobs. And currently, there has been no foundation laid on the record that this was the second, that people were angry and were acting violently.
Also stated that you can lay the foundation.
Yes, Your Honor.
Mr. Ronaldo, have you seen protests around town before?
Oh yeah, there's plenty.
What have you seen in these protests?
Well, I mean, I was just saying, it gets pretty bad. Like people yelling and screaming. The only time I've ever seen more people angry was I was at this DJ concert, right? And I tried to go chicka chicka wow wow on the DJ thing, and it ended up going chicka chicka blow blow. And it was not good. I mean, there were people yelling and screaming at me. It gets pretty bad, is what I'm saying.
Thank you, Mr. Ronaldo. Mr. Ronaldo, I want to talk more about how Mr. Messi reacted when you were speaking about this deal. What did you see him do?
I mean, well, besides getting a little upset, he started talking about, trying to organize people, trying to get them educated, trying to organize peaceful protests and stuff, and trying to save our town, basically. It was pretty inspiring.
Objection. As to 801 hearsay, to the defendant's words, trying to organize peaceful protest.
Response?
Yes, Your Honor. First of all, that would fall under hearsay exception 8033, then existing plan, trying to organize Mr. Messi saying that he is trying to organize protests is Mr. Messi's mindset. It's him explaining a plan that he's having. And second of all, Your Honor, we're not offering this for the truth of the matter asserted that Mr. Messi was going out telling people, or that Mr. Messi, we're not offering this for the truth of the matter asserted. What we're offering this for is to show that Mr. Messi was engaging with these protests in a nonviolent manner, telling people to vote, telling people to organize peaceful protests.
Well,
Your
are
Honor,
you
may I
offering
be
it?
heard?
Well, hold
My
on.
apologies.
The exception would only apply if you were offering it for the truth of the matter. But you're telling me both. You're telling me there's an exception, but you're also telling me you're not offering it for the truth of the matter. So which is it?
Oh, right, Your Honor, maybe I misspoke there. We're not offering this for the truth of the matter asserted. But if Your Honor does find that this evidence is being offered for the truth of the matter asserted, even then it would fall under hearsay exception 8033. It could have been a little bit more clear with that, Your Honor. My apologies.
Response?
Your Honor, we don't believe this is an exception to hearsay under Rule 8033. Your Honor, there is nothing specifically being elicited from this quote about a specific plan. Simply talking to someone about protest isn't an intention of actually planning a protest. There's a difference. And this statement doesn't specifically say, I plan on organizing peaceful protest with other people. Your Honor, they're currently using this for the truth of the matter asserted, and as we already established, it doesn't fall under 8033.
What was the exact language that you're objecting to? What did he say?
Your Honor, if it's better, we can get it from the witness if possible.
Sure. Sir, can you repeat what you said about what Mr. Messi was saying?
Sure, he was talking about, trying to get people voting, educating, maybe trying to get people organized in peaceful protests and stuff. Is that good?
Yes, it is. Thank you. I'll overrule the objection. I'll let it in.
Yes, Your Honor.
Yes, Your Honor. Mr. Ronaldo, had you finished what you were saying?
Oh, I think we got the point. Unless you want to ask me again or whatever. I don't know.
No, Mr. Ronaldo, I don't believe that will be necessary. Lastly, I want to talk about whether or not Mr. Messi owned a firearm. Do you know if he was in possession of a gun?
Yeah, I think he was.
How'd you first find out that he was going to get that gun?
Well, he told me. I think it was the latter half of 24, maybe September.
I want to stop you right there. Specifically, what did Mr. Messi tell you?
Oh, he said, I'm planning to go buy this gun. You never know when you have to save somebody else or yourself. You got it for self-defense, basically.
And do you remember roughly what the time period was that he told you he was planning on making that purchase?
Yeah, like I was saying, latter half of 24, maybe September, October. I'm not quite sure.
Now I want to contrast that with when you found out about the Bed Empire deal. When was it that you first heard about that deal?
I think there was a press release about it.
Would you recognize that press release if I showed you today?
Yeah, I would.
Your Honor, permission to screen share pre-admitted Exhibit 15. That press. Is this the press release that you saw?
Yeah, it is.
What's the press release announcing?
It's the plan to tear down Lisa and, turn it into a big casino or whatnot.
What's the date on that press release?
December 1st.
How'd you come across this press release?
Well, Lee showed it to me.
Do you remember what was the date that Mr. Messi showed you that press release?
I think December 3rd.
Sir, back in September or October, had you ever heard about the Bed Empire deal before?
No, I hadn't. I don't think the deal was, published yet.
Sir, back when Mr. Messi was telling you he was planning on buying that gun, had you ever heard Mr. Messi talk about the Bed Empire deal?
Well, Mr. Austin, like I said, you can't hear about something if it doesn't exist yet.
Thank you, Mr. Ronaldo. I've got no further questions, Your Honor.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Hello, Mr. Ronaldo.
Nice to meet you.
Or dare I say, DJ Twist. You're a skilled DJ, right?
I am, do you follow me on Instagram? You see my clips and stuff?
Sir, we all know you're a skilled DJ. Let's switch gears and see if the defendant was a skilled shooter. Sir, we can agree the defendant is a skilled shooter, right?
I mean, yeah, he's a great shot with the bow, archery club, he's the captain of it.
Right. Mr. Ronaldo, objection, Your Honor, speculation.
Your Honor, may I be heard?
Yes.
Your Honor, I think there might be a bit of a lag on my end because I specifically heard the witness say that they've been in archery clubs with the defendant for years. Hence, it would be under 701, their own rationally based perception. They've seen the defendant hit a bow, hence they know whether or not he's a skilled shooter.
Thoughts?
Well, yes, Your Honor. It may be true that Mr. Ronaldo has got knowledge of Mr. Messi's skill with a bow, but the difference between shooting a bow and shooting a handgun is quite substantial. But we haven't heard any testimony or any foundation today that Mr. Ronaldo is familiar at all with Mr. Messi's skill with a handgun. He can't testify to Mr. Messi's skill with a handgun.
Your Honor, may I be heard?
I'm going to sustain the objection, but allow you to clarify that what you're asking him about at this point is his skill with a bow. And then if you want to try to extrapolate into handguns, that's fine.
Certainly. Now, sir, you'd agree the defendant is a skilled shooter in archery.
Yeah. He's real great at it. He looks like a Hawkeye. He's got like the mask and stuff. He looks great. It's awesome.
He looks great. And you've been seeing him look great on the bow and arrows for years.
Yeah, I think he picked it up in high school, but he's gotten way better.
You've actually seen with your own two eyes just how good he's got it, correct?
Yeah, I have.
You'd agree that to hit the perfect shot, well, you gotta hit something called a bullseye.
Yeah, usually. But unless you're Lionel Messi, where you split the bow right down the middle, you know what I'm saying?
Exactly, sir. Let's talk about what you're saying. Because the defendant has hit a bullseye before.
Yeah, a lot.
Not just one bullseye.
Right, a lot of bullseyes.
A lot of bullseyes, sir. Not just two bullseyes.
Right, a lot of bullseyes, like so many.
Like so many, sir. You've seen the defendant hit 3 bullseyes in a row.
I mean, he's crazy. He's a great shot with the bow now.
Let's see if the defendant had a potential motive to shoot the salesman. Like you just said, you've heard the defendant talk about that, Sam.
The deal, the Ted and Lisa?
Yeah, sir. And yet, we didn't hear you say anything about the fact the defendant's home was going to be sold by that sale.
Well, him and I grew up in the same neighborhood, and we live kind of around there. So yeah, it was all our homes, or it is all our homes still. I don't know what's gonna happen, but
You don't know what's going to happen. Well, sir, let's take a look at what the defendant said when he didn't know what was going to happen. Stating for the record, will now be screen sharing Exhibit 9C, the defendant's journal entries, which are already in evidence. These are the journal entries the defendant wrote.
yeah, I look in his journal sometimes, but don't tell him.
Don't worry, sir, we won't tell him. But you gotta tell the members of the jury, because right here it says, new plan calls for demolishing the Liza neighborhood next summer.
It's the
Right.
Lisa neighborhood, sorry. Yes.
Liza neighborhood. And it actually said they're gonna destroy his home to build a stupid little casino.
That's right, yeah.
It's also right that he said a bunch of traitors. 6 months to stop it. Let's go.
Yeah, that's what he wrote.
Sir, you'd agree with me If I took my hand, covered my eyes, it'd be hard for me to see what you're doing.
Yeah, I think it would.
Let's see if your relationship with the defendant keeps you from seeing the truth. Because you don't want your best buddy to be convicted.
No, I don't.
Because, sir, that would mean you would be in your DJ booth spinning beats all alone.
I mean, no, I have a lot of followers on Instagram, but it'd be sad to not have him there. Yeah,
Sir, you wouldn't have your shoe shining buddy with you.
I wouldn't.
You wouldn't have the one person who's looked out for you your whole life by your side.
Yeah, it would really be unfortunate, but I don't think that's gonna happen because it's not him. I think you guys got the wrong guy, to be honest.
Let's slow down. Now, you just said you don't think it's him. And it's true that you came here to tell the members of the jury that statement.
Yeah, that's right.
Sir, you weren't forced to be here.
No, I wanted to stick up for my friend.
Exactly. The judge didn't tell you to be here.
I don't think he did, no.
Mr. Bailey didn't force you to be here.
Mr. Austin?
Mr. Austin didn't force you to be here, did he?
He didn't know.
Your Instagram followers didn't force you to be here.
No, they didn't.
Sir, you voluntarily testifying on behalf of your best friend, aren't you?
Yeah, I am.
I have no further questions. Thank you, sir. I hope you have a nice day.
Yeah, you too.
Redirect?
No, Your Honor, no redirect.
Okay, this witness may step down. Let's take a moment for the judges to enter their scores. All right, defense, you may call your next witness.
Yes, Your Honor. We call Mr. Andy Morgan to the stand. Good afternoon, Mr. Morgan.
Good afternoon.
Would you please state your full name for the record, spelling your last?
My name is Andy Morgan. That is spelled Morgan.
What do you do for a living?
I currently work as a forensic investigations consultant, and I'm currently based in Pascal, Empyrean.
What sort of educational background do you have to be a forensics investigative consultant?
I have an associate's degree in criminal justice that I received from Empyrean Community College. I also completed basic training in investigative standards and forensic procedures at the Empyrean State Police Academy. And then throughout my career working in law enforcement and investigations, I've also received additional training in investigative procedures at the FBI headquarters.
What about your professional background? Would you tell the members of the jury about that?
I began my career as a patrol officer in the Empyrean City Police Department, or the ECPD. Over the years, I eventually rose to the rank of detective, and I became the lead detective of the ECPD's homicide division. And then more recently, I retired from the force and I began my own private forensic consulting firm where I'm frequently retained to testify in cases such as these.
Your Honor, at this time, we're going to direct the court's attention to stipulation number 14, which states that Andy Morgan is a forensics investigations consultant with specialized training and expertise in forensics analysis standards and procedures and meets the threshold to testify as an expert in that field.
Thank you.
Sir, I want to talk about your work in today's case. What were you asked to do?
I was asked to review the forensic evidence that the state found to use against the defendant in today's case. And I was asked to assess the reliability of the methods that they used to obtain and review that forensic evidence.
All right, well, you mentioned that you were asked to assess the reliability of those methods. Did you use any specific principle or method yourself to do that?
I used a method called comparative analysis. This meant that I reviewed the state's forensic report and compared the forensic and investigative methods that they claim they used in that report to what are generally considered the most reliable methods in the field of forensics. This is the same method of investigation that is typically used by the professional organizations of which I'm a member.
Well, you mentioned that you were asked to compare the state's investigative techniques to what's considered reliable in the field. What are some types of methods that are considered reliable in your field?
There are several that come to mind. Among them, I would include DNA analysis, fingerprint analysis, blood spatter analysis, and gunshot residue testing.
I want to talk about whether you found evidence that the state conducted those tests. Did you find any evidence that the state conducted gunshot residue testing?
I found no evidence that the state's forensic investigators conducted any gunshot residue testing, including no evidence that they ever tested the defendant's belongings for gunshot residue.
Did you find any evidence that they conducted blood spatter analysis?
I found no evidence that the state conducted blood spatter analysis.
Now, you also mentioned DNA and fingerprint analysis. Have you been in court today?
I have been.
Were you here when Detective Beckham took the stand?
I was.
Did you hear Detective Beckham say that they didn't test the entire scene of the crime for DNA and fingerprints?
I did hear that, yes.
Or is that common practice in your field?
It is not common practice in my field, no.
All right, then I want to move on to talk about the evidence that you and the state did gather. Now, did you review any evidence that tracked the defendant's location?
In my review of the state's forensic report, I found that they used a technique called cellular data reconstruction or cellular tracking, which can be used to track a person's location based on the cell towers that their phone is connected to. The way it works is that if a phone is connected to a cell tower, you can assume from that said phone is close to said tower.
How is that cellular data reconstruction applied in today's case?
The state's forensic examiners used cellular data reconstruction to place the defendant around downtown Pascal on the morning of the shooting.
Would you be familiar with a map of that area if I showed it to you today?
I would be, yes.
Your Honor, permission to put up on the screen pre-admitted Exhibit 2C. It's a map with various cell towers on it. Doctor, what are we looking at here? Excuse me, Mr. Horn.
We are looking at a map of downtown Pascal with several cell towers, notable cell towers in the area, clearly marked.
What do those blue towers represent?
Those are the towers to which the defendant's phone connected with on the morning of the shooting.
Now, have you been here all day in court for Mr. Mbappe's testimony?
I have been, yes.
Did you hear when he said the defendant was at Capitol Square?
Yes, I did.
Does that pink circle accurately represent the Capitol Square area?
It does, correct.
Did you hear when he said he saw the defendant at 5:30 and 5:45?
I did, yes.
Now, do you know which tower Mr. Messi's phone was connected to at 5:30 and 5:45?
Yes, it was connected to Tower 1, and it remained connected to Tower 1 from around 1:36 to 6:10 a.m.
Putting this blue circle up on the screen, does that accurately represent where Tower 1 is?
It does, yes.
Sir, do you think it's likely that somebody could be in this pink circle at Capitol Square when their phone's connected to Tower 1?
It's possible, but I would not consider it likely, just considering that cell tower tracking tends to be more accurate in areas such as downtown Pascal that are large population centers.
Thank you. We can take that down now. Now, I want to talk about your conclusions in today's case. Were you able to reach a conclusion based on the evidence?
I was, yes.
What was your conclusion?
I concluded that the state did not utilize reliable methods when when they conducted their forensic review of the forensic evidence in today's case.
Thank you. No further questions.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Good morning, Mr. Morgan.
Good morning.
Let's see if your analysis about the accuracy of cellular tracking is accurate. Your Honor, stating for the record, we're screen sharing the demonstrative used just a moment ago by opposing counsel. Sir, we can both agree that phones don't always connect to the nearest cell tower, do they?
They don't always connect to the nearest tower, no. Whether or not a phone connects to the closest cell tower or one further away is determined by an algorithm that takes distance into account in addition to other factors. I don't have access to the algorithm that was on the defendant's phone, so it's possible that it could have taken in other factors into account. However, that being said, cell tracking data tends to be more reliable in downtown areas where there's smaller overlap between signal ranges, so I'm confident in my findings here.
Well, sir, it sounds like out of everything you just said, there are a lot of reasons why phones don't always connect to the nearest cell tower.
There are several, yes.
It could have skipped cell tower 2 because that cell tower was too busy.
It's possible, however, this happened early in the morning, and I can infer from that cell traffic is typically lower around this time, so I would consider that to be slightly less likely.
Sir, it's just a simple question. The defendant's phone could have skipped cell tower 2 because it was too busy.
It's a possibility, sure.
Yes or no, it could have skipped cell tower 4 because the signal was too weak.
That's also a possibility.
And one more time, there's really a bunch of reasons why the defendant's phone could have chosen to connect to cell tower 1 from that specific period of time.
There are, yes, that's correct.
But the truth is, sir, the defendant's phone connected to every single one of those blue towers the morning of the shooting.
At varying points during the morning of the shooting, that is correct, yes.
The morning of the shooting, they all connected to those cell towers, and they're all within range of Empyrean Capitol Square.
They're all in the general downtown area surrounding Capitol Square. That's correct.
And well, what that means, sir, is that the defendant's phone was at or near the Capitol during the murder.
As I testified on direct, yes, it's likely that the defendant's phone was in the area surrounding the Capitol or potentially at the Capitol on the morning of the shooting.
But not just the phone, sir. Yes or no? You think the defendant was at or near the Capitol during the murder?
I think it's a possibility that he was at the Capitol, and I think it's likely that he was in the general downtown area on the morning of the shooting. That's correct.
Sir, is that a yes to my question?
That's a yes to your question.
Sir, so today you heard your attorney say close enough isn't good enough, Ola? Let's see if you looked at enough evidence. If I were to hold this book up and just took a page from this book and asked you to read it, well, it's fair to say you wouldn't understand the full story.
I might need a bit more context, sure.
Right, because for this story to make sense, you've got to read the book.
I assume so, yes.
Similarly, if you only look at a fraction of the evidence in a full case, well, you might not get the full picture.
That's correct, yes.
And in today's case, you only looked at a fraction of the evidence.
I reviewed all of the evidence that the state's forensic examiners relied on when coming to their conclusions. This was all of the evidence that was relevant when assessing their report. That is not all of the evidence, but it is all of the forensic evidence in this case.
Sir, you keep avoiding my questions. I want to see why that might be. Because you're not testifying for free today, are you?
I'm being paid for my work in reviewing the forensic materials in today's case, yes.
You're being paid by the defense.
Yes, that's correct.
$58,000.
That is accurate, yes.
That's a whole lot of money, isn't it, sir?
I would say it's a standard rate for the amount of work that I'm being retained for.
So let's pick back off where I left off a moment ago. You only looked at a fraction of today's evidence.
I only looked at a fraction of today's evidence, but I examined all of the state of today's forensic evidence, which is what I was retained to do.
But what you didn't look at, sir, was all of the witness statements.
With the exception of Dr. Rapinoe's, none of them contained any relevant information concerning the state's forensic audit, so I did not see the relevance in reviewing them, no.
That wasn't my question, sir, about the relevance. My question was whether or not was that you didn't read all the witness statements.
I didn't. None were provided in the state's forensic report.
They also didn't provide to you all of the exhibits.
No, only the ones that the state relied on when coming to their forensic conclusions, which I believe were exhibits 1 through 5.
All right, well, I just want to take a step back and finally talk about something we can agree on. One of the few things you actually did investigate, you investigated the weapon that was used to shoot the salesman.
I did, yes.
You're familiar with the model of the gun the defendant owned.
It was a .40 caliber Glock 22 handgun, a fairly common model.
A Glock 22 .40 caliber. Well, the bullet casings that were used to shoot the salesman also came from a Glock 22 firearm.
They were .40 caliber bullet casings. That's correct.
Exactly. Shot those exact same .40 caliber rounds.
Not that we have no evidence that they are those exact same .40 caliber rounds. All we know is that they are the same make and model as the ones that the defendant's handgun would use. Again, no DNA or fingerprints were tested. The state did not conduct DNA or fingerprint testing of those shell casings. So it's impossible to know whether or not those were the exact same ones using forensic evidence that the defendant would have used.
Sir, I only have one last question for you. It's a simple question with a simple yes or no answer. The shell casings found from the crime scene, well, they're from the exact same model of the gun the defendant owned, right?
They were, if you're asking if they were from the same model, then yes, that is correct.
Thank you, Mr. Morgan. Nothing further, Your Honor.
Thank you, counsel. Redirect.
Yes, Your Honor. Mr. Morgan, on cross-examination, opposing counsel asked a lot about the evidence you reviewed. Now, were you present for all of today's trial?
I was, yes.
Did you hear all the evidence that the state presented?
I did, yes.
I also want to talk about what you heard in today's trial. Now, did you hear whether the detective in today's case tested the entire crime scene?
From what I heard, the detective...
Outside the scope of cross-examination, if I may be heard.
Yes, ma'am.
Your Honor, throughout my cross-examination, I asked nothing about what the detective said on their direct examination and about the prosecution's forensic works from the detective specifically. So, Your Honor, right now, opposing counsel going into these testimony, that's not something brought up on cross-examination, and they're not allowed to go beyond the scope of it.
Response?
Yes, Your Honor. Opposing counsel on their cross-examination talked about the forensic evidence that the state presented versus the forensic evidence that Mr. Morgan reviewed. They said that Mr. Morgan only reviewed a fraction of the evidence, and we're saying that the state did the same thing. This is certainly within my right on redirect examination, as the state asked about their forensic techniques. Though they didn't use Detective Beckham's name, I'm allowed to ask about forensic techniques that the state used on redirect examination. That's well within the scope.
One more response.
I'll overrule the objection.
Yes, Your Honor.
Did you hear if they tested the entire crime scene?
From what I heard from the detective, they did not test for DNA or for fingerprints.
Did you hear that they only tested just a fraction of the evidence?
Yes, I did.
Thank you. Nothing further.
Any recross?
No recross, Your Honor.
Okay, this witness may step down. Defense, anything further?
No, Your Honor. The defense rests our case in chief.
Okay, as per the rules of procedure, we will take a 5-minute recess before closing arguments, again, unless either side has any objection. Okay, seeing none, timekeepers, please start the clock for 5 minutes. Okay, let me just confirm that we have everyone back.
The state's here and ready to go.
Okay, and for the defense?
Yes, Your Honor, we're here and ready to proceed.
Okay, we will hear closing arguments at this time. I'll turn it over to the prosecution.
Yes, Your Honor. To save his home, he shot the salesman. The sand in this glass isn't just sand. It's a symbol of time. And the defendant had his own hourglass. Every single time a grain dropped, a pit in his stomach grew. His anger formed because he knew he didn't have enough time to stop that sale from happening. And the defense is right. Because you learned for months she watched a billionaire salesman destroy their home. Every protest stopped to fail the sale. Or rather, fail to stop the sale. And being so close to losing his home in December 2024, the defendant knew. He knew he had one option. Play Robin Hood. Take his gun and use it to steal a rich person's life to save poor families from losing their home. Because to save his home, he shot the salesman. Because there is no doubt about it, everyone in this case threw a short stick, but members of the jury, today we ask you to remember that justice doesn't take a political stance. It stands for the truth. And we charge the defendant with first-degree murder of the salesman, Ronnie Goodell. Now, we had to prove two things. One, the defendant intentionally shot the salesman. And two, those shots caused his death. And the defense is right. Close enough isn't good enough. So let's talk, or rather, let's take a closer look at the three facts we met our burden with. The shooting, the sale, and the suspect. First, the shooting. You learn from an Uber driver who was close enough and had a good enough look at the shooter. All eyewitnesses reported seeing the shooter with three things: dark clothing, a duffel bag, and a gun. Do those items sound familiar? Well, you heard from the detective that inside the defendant's duffel bag was a dark hoodie and a gun. Now, those items you see on screen match the defendant because the defendant was the shooter. That is the only reasonable explanation. Because unlike the defense witnesses like to say, well, that's a generic hoodie, that's a generic duffel bag, members of the jury, that gun, well, it was the same gun that shot the salesman, same type too, a Glock 22. So let's talk about our second fact, the sale. You learned from the senator that the sale would destroy homes to build a casino, leaving the defendant displaced. Now, the defendant's own best friend got on stand and talked a lot about the defendant's words of being a peaceful person. But take a look at the defendant's journal entries. Stupid little casino. A bunch of traitors, 6 months to stop it, let's go. The defense wants you to believe that these notes were about a peaceful protest. But members of the jury, there's nothing peaceful about that. Calling people traitors, calling people bullies, that's not peaceful. It's motive. Because the very next day, the salesman was shot, and that's not a coincidence. It's called premeditation. And third, the suspect. Now, you heard from the defendant's own expert witness on cross-examination a few moments ago that the forensic evidence tied the defendant to the scene of the crime because they knew they were at or near the Capitol. And the defense is right. good enough isn't, or close enough isn't good enough. But we have eyewitness testimony placing the defendant at the scene of the crime. Eyewitnesses saw the defendant walking down the street. They saw her face, and they said, that is Leland Massey. Now, the defense says the defendant was misidentified. And at one point, they were right, because the defendant misidentified herself to the police. Let's set the scene. Days after the shooting, police approach her, ask her to identify herself. And she reaches in her pocket and hands them a fake ID. Fake name, fake address, fake birthday. An innocent person doesn't lie about who they are. Why did she have a fake ID on her? What was she trying to hide? Her guilt. Because today we prove beyond a reasonable doubt the defendant shot the salesman to save her home. That's the only reasonable explanation of the defendant lying. Now, the defense has told you 3 questions today. Let's take a close look and see all the evidence we use to prove their questions. 1. Leland Massey was the only one who could have committed this crime. He heard from the journalist who wants to crack the case about gentrification and steamrolling. Did you hear from the police that they found a single shred of death threats or angry tweets, words of somebody wanting to kill the salesman? No. Because we have the defendant's words, and on direct examination, the detective told you the defendant was the only one who said anything like that. Second, we have good evidence. Now, they keep talking about a silencer, but you heard from multiple eyewitnesses, not just 1, not just 2, but 3, that they heard loud gunshots. Members of the jury, there was no silencer to begin with. And that's why when you saw a picture of that gun, there was no silencer. Because eyewitnesses heard the gunshots. They heard the defendant shooting the salesman to save their home. Now, in a few minutes, you're going to head back into that deliberation. The judge will give you a verdict form, like this one. And out of all the evidence they showed you, it will boil this case down to a simple question. Count 1, guilty or not guilty? And when you're holding that pen, members of the jury, you gotta remember something else written in pen. The defendant's words. A bunch of traitors. 6 months to stop it, let's go. Because the defense is right. Close enough isn't good enough, and that applies to justice as well. We proved our case to you beyond a reasonable doubt, so we know you'll check guilty because the defendant shot the salesman to save his home. Thank you.
Thank you, counsel. Defense?
Yes, Your Honor. May it please the court.
Yes, ma'am.
There's something missing from the story the state's been telling you. We haven't heard anything about any forensic evidence connecting Leland to the scene of this crime. Any DNA or fingerprint evidence showing that he was ever connected to Mr. Goodell's death at all. The state told you about some clothes, about a bag, about a gun, but not one single shred of physical evidence connecting Leland to that crime at all. And that's because the state, they think that close enough is good enough. But that's not how our justice system works. So let's take a moment to examine what the law actually requires. Because every single person who walks into this courtroom is presumed to be innocent. Not innocent until proven likely or innocent until things look close enough. Innocent until the state meets their burden of proof beyond a reasonable doubt. Now, you've heard those words quite a few times today, beyond a reasonable doubt. But what do they really mean? Well, as the judge is going to instruct you, it's the highest standard of proof in our justice system. And it means that at the end of today's trial, right now, if you think there are gaps in the state's story, or just you have some important questions that they haven't answered, then you can't find Leland Massey guilty. And as you prepare to go into your deliberation room and make your decision, I want to walk through some of those unanswered questions. How reliable is the state's evidence? Is Leland Massey the only one who could have done it? And why doesn't Leland Massey match the description of the shooter from eyewitnesses? So let's start with that first question. How reliable is the state's evidence? Because the truth is that there isn't any evidence. The state wants you to convict based on assumption, not proof. On what they think happened, not what they can prove. Because here's what they didn't do. No gunshot residue testing, no blood spatter analysis, no fingerprint testing, no DNA testing, no fiber analysis, no forensic evidence. Nothing that ties Leland Massey to that scene. And you heard that that wasn't a mistake. It was a choice. The lead detective today told you under oath that she didn't even try. Didn't even try to collect fingerprints, didn't try to test for DNA. Our expert told you that that's not standard. That's not how you run a serious investigation. The state stopped asking questions because they thought they already had the answer. So what did they bring you instead? 2 eyewitnesses. One said she saw the shooter, but then admitted that she had a concussion and couldn't remember key details. The other said he was sure that he saw Leland around 5:30 and 5:45, but the timeline doesn't match that evidence. Cell phone data shows Leland's phone across town at 5:30, not at Capitol Square, not at the scene, not even close. So what are we left with? One witness whose memory can't be trusted, and another whose story is directly contradicted by the science. Members of the jury, when stories don't match, that's not proof beyond a reasonable doubt. So let's move to that second unanswered question. Is Leland the only one who could have done it? Because the state's been acting all day like Leland had some sort of unique motive. But you heard today from Harper Solo that that's not true. That there were a lot of people in the community who were angry with Ronnie Goodell. And Ms. Garcia told you that we didn't present you with any death threats or direct communications from those people to Ronnie Goodell, but neither did they. They haven't showed you any link between Leland and Ronnie Goodell or any reason why he, out of everyone in the community who resented Mr. Goodell, would actually want him dead. Without that, that proof just is not good enough. That brings us to our third unanswered question. Does Leland match the description of the shooter from eyewitnesses? Because the state's been telling you he does because he wore dark clothing, had a dark duffel bag, and was carrying a gun. But you learned today that the clothes the shooter was wearing was black. But Leland's, they were green and gray. The duffel bag the shooter was carrying was black. But Leland's was blue. And you learned that that gun, the lead detective in today's case concluded that it had a silencer on it. And Leland's, it didn't. The state's 2 eyewitnesses, they both took the stand. And they told you that they were 100% sure that the shooter was dressed in all black, head to toe. But Leland Massey wasn't. That's a mismatch. That's a contradiction, and that is not good enough. So I'd like to talk about what the state's been telling you. They told you that Leland Massey shot the salesman to save his home. But let's take a step back and think about who actually proved that. Not the state, not the evidence. That's just a story, a guess, a theory, a dramatic line that sounds pretty good until you look closer. Because if that's what really happened, then why is there evidence not tying Leland to the scene of the crime. Why didn't they test for fingerprints or DNA? Why did their own lead detective not follow standard procedure? They want you to believe that he shot the salesman to save his home, but we've been here for hours, and they couldn't even prove he was there. Their whole case is built on what sounds like motive, not what on the law actually demands proof. If he actually shot the salesman to save his home, you'd expect the evidence to back it up. But the evidence doesn't say it at all. The evidence says nothing because they never found any, because they never looked for any. So here's the truth. The state wants to win this case on a slogan. But we don't convict on slogans. We don't convict on sympathy. We convict on evidence. And they simply don't have it. Now, I understand that it might be easy to take the state at their word, to look for answers to Mr. Goodell's death. I want answers too. But we don't come into a courtroom to do what's easy. We come into a courtroom to do what's right. And what's right today is to find Leland Messi not guilty, because close enough is never good enough. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. Close enough isn't good enough. But when it comes to the defendant, he's not just close. He's the only one who fits the facts. We convict on evidence, so let's walk through the evidence that we showed you today. The forensic investigator knew the defendant was a suspect by using evidence. They relied on not just one, not just two, but 3 eyewitnesses who described the shooter matching all the features. Then, the police found the defendant with a gun that matched the bullets from the crime scene. And then the police found a journal where the defendant wrote about how much he hated the victims. Even the defendant's own experts agreed that he was at or near the crime scene when the salesman was shot. No other suspect fits the facts like the defendant. Because when you look at the evidence close, it proves that we met our burden. Because everything points to the defendant shooting the salesman to save his home. Find him guilty. I appreciate your time.
Thank you, counsel. All right. Thank you all for your presentations today. The judges are going to take a few minutes to complete our ballots. You're welcome to use this time to stretch or use the restroom, but please come back as soon as you're done with that. And jurors, if you would please let me know when you completed your ballot. Probably the easiest way is to, you can turn your screens off now and just turn them back on once you're done with your ballot, so I can track it that way. All right. Thank you. So judges, I see that you're all back. We have to wait for, I think, the blue shirt to let us know that they're good with all of our ballots. So we'll just wait on that. Okay, I've gotten the all clear for us to proceed. So are both sides back? Okay, I see the prosecution and the defense. Okay, fantastic. So I know that what you care about at this point is results, not from hearing from any of us. But I think we have to give you a little bit as we wait for those scores. So we're going to go just down the horn and, honestly, 30 seconds is probably more than sufficient. Just tell them who you are and any overall comments. I'll begin. My name is Josh Burgess. I am a high school mock trial coach who has coached at Empire and state and nationals, and I'm a district judge here in Texas. The thing that super impressive performance by everyone. The thing that stood out to me was listening. The ability of both sides to listen to what was happening in the round contemporaneously and deal with it, particularly in hearing what witnesses said and using it against them, was really impressive and frankly the hardest thing to teach students. Really well done. So we'll continue in the way I see it on my screen. Mr. Smith, you can go ahead and give your comments.
Yeah, I'm Wes Smith. I'm an attorney in Virginia. I've coached high school mock for about 6 years, and I know you guys are really just interested in the results. I've been sitting where you're sitting before, so I'm just going to leave it at that, other than to say that I really enjoyed the round.
Thank you. Ms. Carlson?
Hi, so I did mock trial all 4 years of high school. I've been coaching Empire State Nationals about the past 10 seasons. I'll keep it really brief here too. I would have appreciated seeing more objections. I think there were 3 witnesses that there weren't any objection battles. Just keep in mind that's something that we're judging on. So any opportunity you have to demonstrate your knowledge of the rules of evidence, make sure you go ahead and take that opportunity. Otherwise, great job from both sides. It was a very fun round to watch.
Thank you. Ms. Moore?
Hi, my name is Hannah Moore. I'm an undergraduate student at IU Bloomington, so I do mock trial there. This was an excellent round. You guys were all great. And like the presider said, your ability to listen and react to things that were happening in the round in real time was really impressive. So you should all be really proud of yourselves.
Thank you. Mr. Strauss?
Hi, my name is Eric Strauss. I coach a high school team that was lucky enough to win 2 of the 3 Empire competitions this fall. So I've been exactly where you guys have been this fall, and I thought both teams did an absolutely fantastic job. Both teams are very deserving to be here. Congrats to both teams.
Thank you. Ms. Fortunato?
Hi, good afternoon. I have been judging with Empire for a few years now. I'm a trial attorney with the Legal Aid Society in New York, although I live in Georgia. Long story. I think everybody did really well. I agree with, I think it was Ms. Carlson about the objections. I was hoping to hear more. The ones that were made, I thought were pretty good in terms of your knowledge of the rules of evidence. But that's always a really great way to, keep your opponent, I guess, on their toes. And so definitely useful. But I think you all were just very impressive. I'm always just blown away. So thanks for participating.
Thank you. Mr. McGinnis?
Thank you very much. I'm an attorney in Minnesota. I judge high school and college mock trial a lot. I have been to the many national tournaments, including this year, the high school tournament in Phoenix. I've seen a lot of mock trials where I thought that the 2 teams were in different rooms, not listening to each other and not paying attention to each other and doing their own thing without any relevance to each other. What was extraordinary about this trial, and others have said it, is the extent to which both teams clearly paid attention to everything the other team did and provided comments to it, responses to it, or paid attention to it in some way that showed they were listening to it and dealt with the issue. That was a truly extraordinary thing about this trial, and represents the excellent qualities that need to be brought to the practice of law, is paying attention to what's going on. So thank you for a good day's work.
Thank you. Ms. Gatson.
Hi, everyone. My name is Melina Gadsden. I did high school mock trial for 3 years. I've competed at Empire Chicago and online. I'm currently an undergrad at Emory University, and I'm on their mock trial team. Great side, good. Well, wow, great job to both sides. Congrats on making it to the final. I'll leave you with one comment, and that would be on props and demonstratives. When you use a demonstrative, be sure that when it's on screen, it is worth it to your case. Be sure that it's not blocking your performance more than it helps you. Be sure you can possibly use it again in the future throughout the trial. And in terms of modifying the opposing side's demonstratives, be careful that you're not accidentally testifying for the witness. Get a clear yes or no before you modify that exhibit that will call for attorney testifying. But I'll leave you with that. Great job, everybody.
Good stuff.
Hi, I'm Julie Staub. I coach mock trial at California team that have been at Empire multiple times. We love Empire. I thought this was a fantastic round, and I particularly liked the witnesses. Some of the witness characters were fantastic. I really like how you incorporated your character through Cross as well. Yeah, great advocacy skills on the part of the attorneys, and like everyone was saying, I really felt like I heard the themes throughout the entire trial, and even using the other team's themes to help your side was very effective. So great job.
Thank you, Mr. Kim.
Hello, I did mock trial all through high school, and I'm currently an undergrad at Northwestern, currently on their mock trial team. So some comments are, I just want to say, first of all, like others, great job on the active listening. I could really tell that you guys are paying attention to each other's arguments, especially during objection fights. That's where I saw that happen most often. And some of the witnesses, I couldn't really stop smiling, so I had to sometimes turn off the camera. And then some of the witnesses, I really could believe what you knew what you're saying. So that's really good for example, an expert witness. So yeah, great job on both the attorney and the witness side. I can't really say anything bad about this round, honestly.
Thank you. Ms. Rothstein.
Hi, thanks. I'm Lisa Rothstein. I'm an attorney in California, and I coach a high school team out here that has been to Empire multiple times. And I really love this competition, and I really love mock trial. So thank you all. It was a great round, great responsiveness. I guess if I was going to give a single comment, I know that we all like to do the performative, exciting witnesses with the accents and the craziness. I think for me, like with a murder trial, I like to see perhaps a little more solemnity around what's going on and the implications of what's going on. So while I enjoyed it, I think you're all spectacular. For me, by the time we got to that last witness and he was just kind of a dry nerd, I was really thrilled to see that kind of brought back down to earth and the groundedness of that testimony and that direct. So, but anyway, really terrific round. Thanks you all. Thanks to all of you for your efforts here. Can't wait to see how it comes out.
Miller.
Hi, my name is Emily Miller. I am one of the captains for the University of Central Florida's mock trial team. Again, I second everything that's been said so far. Both of you guys did great. The main thing that I noticed is y'all's ability to match your witness's energy, both on direct and even on cross. The only thing I love more than a witness that commits to the bit is an attorney that commits to their witness's bit, and you guys did great with that. Also, again, with the changing things on the spot and making adjustments, even I judged both of you guys yesterday, and within that 24 hours, there were a lot of things that you fixed and improved on that really show. So keep up with that. Y'all did great.
You, Mr. Stevenson.
Hi, everybody. My name is Paul Stevenson. I am going to be a sophomore this fall at the University of Notre Dame on their mock trial team. I did a high school mock trial in Pennsylvania and competed in Empire. So I did a high school mock for 4 years. So this is my 6th year of mock trial, as terrifying as that sounds. I also still coach a high school team in PA. So super happy to be here and see an incredible round on both sides, really. Having judged this for the last couple of rounds since the prelims, this was definitely the most cohesive on both sides I've seen for prosecution and defense, laying out the entire case all throughout. So I really appreciated that. I took a ton of comments. I know they won't really help with this case again, but moving forward, for you guys to reference, I'll keep it short really quick. One witness bit and one attorney bit. Attorneys, objections. I know it's already been said. Even if you don't think you're going to win an objection, sometimes we had 3 directs we counted without objections. You can make objections just to break the flow, especially I felt like the detective and the character witness for defense were both really effective directs. And sometimes when they're hammering home on points, object just to break the flow. Because like rhetorically as a jury, when we're sitting here and watching that, we'll forget what they're saying and that will take them out of their rhythm and kind of take away from like the rhetoric they're giving us in like terms of what we're thinking. So even if you don't win, you could still win in terms of our thought process and taking that away. And then so that goes for attorneys. And then for witnesses, I would say I said it yesterday, and I think this was one of the best rounds I've seen with it. But again, for some of you, oh, sorry, my phone. But just keep thinking about what your witness really cares about. Some of you argued a little bit too much on something. Some of you were great and you only argued on the things you needed to, especially since we didn't have a defendant testifying this round. Just think, whether you're the expert, whether you're the character witness, what if I'm actually this person? Do I care about? Do I just want to leave? Do I actually want to fight on this? Just consider that. And that's how you really take it to the next level and make the jury believe you are that character. But awesome job all around.
Thank you. Mr. Sullivan.
Thank you. Hi, everybody. Donald Solomon. I have judged. I've been a juror. I coached. I've been a trial lawyer for 47 years in Chicago. That's what I've done a lot of. The trial was extraordinary. I mean, I could go on for hours about that, but I won't hold you. If I say that, believe me, it was really a great round. I want to follow up on one thing that Paul just said, though. I want to take a little bit of an issue with that on objections, okay? Objections are important, but I would really want to caution you and stress this. The purpose of the trial is to get as much to the truth as you can as to what's going on. If the guy is guilty, he deserves to go to the can, but the state has to prove that, not the defendant. If the guy is innocent, the defense has to do everything they can to poke holes in the state's case. They don't have to prove him innocent. And oh, a quick thing, when you're on the defense, you know, you don't want to say that you want to find that the defendant is not guilty. Not that he's not guilty, he's not guilty on the verdict. Put those 2 words together for the benefit of the jury. There's guilty and then there's not guilty. It's not guilty and innocent, it's guilty and not guilty. An objection can be used to interrupt the flow and the momentum. That part's true. But sometimes that's not necessarily good for the jury. Understand that your opponent may be doing it exactly to break up the flow because you're being effective in communicating to the jury. But you may want to watch out for that as the attorney because it can backfire on you. It's like, hey, you know, we're getting the story here. Why is he objecting? You know, don't break this up right now. I want to hear what he has to say. So be judicious, be very careful about how you use objections. You're either using them to stop an improper question from happening or getting an inappropriate question and an inappropriate answer, or you're doing it to basically disrupt the flow of the trial. Know which reason you're doing it for and be very careful if it's just to disrupt the flow. The other point I want to make real quick, besides know your audience, and you are all phenomenal, okay? But you have lawyers, you got to know when to stop. You got to know when to stop. When not just on direct is easier, but you got to know when to stop on cross. There's, for all of us, we all want to just ram that point home at the end and say, aha, I got you. Don't resist that. The jury will let the jury get there by themselves. Lay out your foundation, make all your points, and then let the jury come to the conclusion, oh, okay, well, I can connect these dots. If you try and do it for them, you may go overboard, you may open the door, and on redirect, you're going to find the lawyer coming back and fixing and patching up the weak spot that you just pointed out by going beyond. So I have a whole bunch of stuff I could say, but The last thing, know your facts. Please, both sides, know your facts cold, backwards and forwards. If you ever want to test yourself, give yourself different parts as you go over this and over this and over this and see how it feels to be a witness or the lawyer or the judge or a juror. Each time you're sitting in a different chair, you're going to get a different perspective. It can only help you when you're hearing it or when you're doing it yourself. You are all terrific. Thank you for a really, really, really great round. It's been a privilege to sit and listen to this one. Thanks.
Thank you, sir. All right. I think I've covered all of our jurors. Okay, fantastic. I'm going to turn it over to Empire to find out who won this round.
Thank you, Judge Burgess. And I want to specifically thank you for presiding over this round. And I want to thank our incredibly wonderful volunteers for taking time out of their day to support us. This was an incredible round. We had 16 scores in our final round. So now, let's get on to our winner. And with a win of 9.5 ballots to our runner-up with 6.5 ballots, the Spring League's champion is Ann Arbor Community High School. Congratulations. And congratulations to both teams for an exceptional final round. You all have a lot to be proud of.
Thank you, judges, and congratulations, guys. You did great.
Thank you. It was a
you.
super fun trial.
Yeah, it was a pleasure.
Yeah, thank you.
Thanks to the judge. You did an excellent job, Judge. Thank you.
Thank you. Y'all have a great day.
Take care.
Thank you.
Okay, bye. Oh, leave.